right, so that's the only segment I'm going to do today. It was a long one. It's like a 30-minute segment, but I think it was good to do, right? People already in the chat beating me to it. Supreme Court, U.S. Supreme Court released their order list today. Let's pull that up because you've got the Snope case denied. Snope v. Brown, statement from Kavanaugh. Maryland, that prohibits AR-15s are something of an outlier. Oh, where are we at? Let's go. Let's up here. Here we go. All right. David Snope versus Attorney Brown. Anthony Brown, Supreme Court. Petition of writ certiorari is denied. Justice Alito, Justice Gorsuch would grant the petition for a writ. Here's a statement from Kavanaugh saying, respecting the denial of cert, this court ruled that the Second Amendment must be interpreted in light of constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because handguns are in common use by law-abiding citizens, the court held that the District of Columbia's ban on handguns violated the Second Amendment. The court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historical-based common use tests with respect to the possession of particular weapons. They go on to say, this case primarily concerns Maryland's ban on AR-15s, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s, and AR-15s are legal in 41 of the 50 states, meaning the states such as Maryland that prohibit AR-15s are something of an outlier. Goes on to say, given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that the AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment. Goes on to say, if so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. Under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15s at issue here from the handguns at issue in Heller. AR-15s are semi-automatic, but so too are many handguns. Semi-automatic handguns and rifles are distinct from automatic firearms, such as the M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. In short, under this court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies cert, a denial of cert does not mean that the court agrees with a lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeal, including in Illinois, where there's a significant record in the Illinois challenge of comparing semi-automatic firearms to military-grade firearms. And you can hear in there in the what Kavanaugh's writing here about the distinction between AR-15s and M16s. Again, you can see here some of the other cases that are pending. You've got a case pending appeal with the National Association for Gun Rights versus Lamont. You've got the Association of New Jersey Rifle and Pistol Clubs versus Platkin. You've got Veramontes versus Cook County here in Illinois. You've got Miller v. Bonta, and is that California? Again, you've also got the case here in Illinois, the state case where the Barnett is challenging with three other plaintiffs groups. That was found unconstitutional in the district court, and it's pending in the appeals court. And we've got some filings that are going to be happening this week in that. But anyways, opinions from other courts of appeals should assist the court's ultimate decision-making on the AR-15. That's a huge sign there that a state like Illinois with its case could be instrumental and fundamental in making this decision for the U.S. Supreme Court. Back to the ruling here, denying cert in the Maryland gun ban challenge, Kavanaugh says. Additional petitions for certs will likely be before this court shortly. And in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. So there you go. All right. Then you've got Justice Thomas dissenting from the denial of cert, and you can go and read that as well. So that's, again, where we're at in the gun ban challenges with the U.S. Supreme Court denying cert in the Maryland case. It took them, 16 weeks or so to actually get that together. It's pretty fascinating to track all of this. We'll continue to track it for you here with Illinois in Focus Daily. I want to give a big shout out to the chat room. Pretty good viewership this morning. I think people really wanted to see what was going on at the State House.